Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about reinstatement of removal. Reinstatement of removal and possible relief and what to do if you're subject to reinstatement. Reinstatement of removal occurs when a person either was physically removed by the United States government out of the United States due to a removal order, or left under the order of deportation, meaning that not the government, it was not the government who removed the person, but the person, him or herself, left after the order was issued. And then the person illegally re-enters back into the United States. In this situation, the United States government, Department of Homeland Security, does not really need to place the person into removal proceedings again, but rather can reinstate the prior order of removal. There is special procedure for that, but the problem is this. When someone is subject to reinstatement, he or she usually, often, cannot challenge the underlying order of deportation, removal that was issued. And that presents a problem. So when someone is subject to reinstatement of removal, his or her options of how to fight it are very limited and will depend very much on details of the case and what happened prior in the removal proceedings, why the order was issued, whether your rights were observed or not, and also will depend on what's happening with you now, if you qualify for any relief, very limited specific relief now. So let's talk about it. Reinstatement of removal is something that issued by the Department of Homeland Security. It's so-called administrative order. It's not going to be issued by the judge. The government may reinstate the order or may not. It depends on the government. But if it does, it will have to give you a notice of that. And once the reinstatement is issued, you will lose many of your rights, including usually the right to challenge the underlying order of removal that was issued to you in the first place. However, here is a catch. The catch. Sometimes you can challenge that order. Many courts decided that you can if there were violations of your fundamental constitutional rights or gross miscarriage of justice during the first time when you were ordered removed. One of such violations, for example, would be lack of proper notice of the hearing. By the way, the motion to reopen based on lack of notice of the hearing may be filed at any time, and it can be filed once. So if you do it the right way the first time, not to lose your chance. So basically it means that when you're subject to reinstatement, you should, or your lawyer at this point, have to try to see if there are any grounds at all to challenge that first order by filing, let's say, motion to reopen. And if you do, then reinstatement will not have any meaning, right? Because there is nothing to reinstate. That order is not valid. That's one of the ways to challenge that. Now, there are also other ways. For example, a person who is a beneficiary of a U visa, U status visa granted in the United States, for that person, administrative orders issued by the Department of Homeland Security, including expedited order of removal, reinstatement of removal, administrative removal, will be automatically canceled by the operation of law, but only orders of removal issued by administratively by Department of Homeland Security. And of course, a person has to be beneficiary of U visa. And I'm going to tell you that currently it takes a long time to become beneficiary of that U visa. But it's possible, of course. So that's another way to basically clear the situation up to get rid of that reinstatement. And one more way would be not to fight the reinstatement per se, but to allege the defenses still available to you, because there are a couple of defenses that you can still use even if you are subject to reinstatement. Those would be withholding of removal and relief under Convention Against Torture. And the way it's done is that once you're subject to reinstatement, you receive a notice, you state that you have a fear of coming back to your country, and the government has to provide to you what's called reasonable fear interview. And if you pass the interview, then the government is going to issue a notice and your file will be transferred to immigration court, and there in front of a judge you will be able to present your case for these reliefs that can be presented only in front of an immigration judge. Currently, of course, there is a little issue with all this process, beautiful process that's described in the books, is that person will likely to wait for a very long time unless they're detained for the reasonable fear interview. Still possible, and you most likely the person will be released on order of supervision and even will qualify for an employment authorization, but will not be able to present his or her case for a long time until he or she gets this interview with an asylum office and has this step cleared up. So basically, what you would do is you would try to challenge the underlying order if there are grounds to it. You would see if you qualify for something like a U visa or T visa, where you have a waiver, automatic cancellation like with a U visa, maybe a waiver available. By the way, VAWA applicants may qualify for a very narrow waiver of the bar subject to the permanent bar, or you would apply for withholding of removal or cancellation or relief under Convention Against Torture. Other than that, pretty much reinstatement is not easy to deal with. It was possible before, I'm not sure if it's still going to be possible sometimes, to negotiate with the prosecutor, to ask the prosecutor to, or the government, to place a person into regular removal proceedings rather than reinstatement. So that may be a move also that can benefit the person depending on the circumstances. And of course, there are procedural considerations as to how the reinstatement should be done, but that's a subject of a separate topic. So I hope this video was helpful. If you are or may be subject to reinstatement, it's something that you need to be ready for. And you may read more about immigration topics and various reliefs from removal on our website, www.shautsova.com. Thank you.